All right, this is docket 20-365 FC, People of the State of Michigan versus Matthew Weston Goff. Counsel, your appearance for the record.
Andrea McCray, appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, standing in for Mr. Silverthorne today, and on behalf of Matthew Goff, who's standing to my right today.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
You may put your hand down. Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
All right, thank you. You, there's a number of issues on your file that we need to make a record of, but you have had Mr. Silverthorne. I have removed Mr. Silverthorne from your file. I don't care if you want him. It's been 5 years. This is going to trial. Mr. Silverthorne has had a number of issues. It is not his fault. When I was in practice, I had hundreds of cases with Mr. Silverthorne. As a judge, I've had probably thousands with him in front of me. He's an excellent attorney, but his health has not allowed him to proceed, and I will not allow any more delays. There is one, I'm granting you, this was supposed to be heard February, what, 27th or something?
Yes, Your Honor.
I've given you a couple more weeks and that's it. We're done. There's no more delays, no more excuses. So Mr. Feigelson has been appointed to represent you. I have required of him to get a second chair from his office so that we don't have any more delays or attorney's excuses. The people are also on notice. We are going to trial. That's your right. That's what you've wanted. That's what the victim wants. So we're going to trial. There is no more delay. You can choose to represent yourself, which I don't advise. I would give you backup counsel, and it'd be Mr. Feigelson. You can choose to retain an attorney. That attorney is going to come to me and say, I need more time. It's your right to get retained counsel, but I'm telling you, I'm not delaying this. If you get retained counsel, Mr. Feigelson will then be the chair. We cannot have delays in this matter anymore. So there's my spiel. I don't know how you feel about Mr. Feigelson not being on your file, but he's just simply unavailable. That's God's decision, not mine. Ultimately, it comes down to me having to make the decision because he has not been able to go to trial for many reasons. And like I said, I think the world of him. But the process is the process, and this is no longer, there's no speedy trial for you, and there's no speedy trial for the victim, and we operate under speedy trial. So in regard to what I've just said, what would you like me to know, sir?
I understand.
Okay, great. That's great. So Mr. Feigelson is also a very fine attorney. He's in front of me all the time, knows what he's doing. We're going to get a second chair, so there's no more delays, and you're going to have two attorneys instead of one, right, Mr. Feigelson?
Judge, that is correct, and I do understand the court's position with regards to Mr. Silverthorne. Mr. Silverthorne has been on this case from the beginning for 6 years. I'm not certain for the delay, but I don't believe any of this delay is attributable to either Mr. Goff or to my client. And I think it's a little unfair to Mr. Goff to have Mr. Silverthorne be completely removed. I know he's had some medical issues, but my understanding is he will be back in April. I know we asked for an adjournment out until May or June or July, so we allow Mr. Silverthorne the opportunity to come into this case, a case that he's lived and breathed for 6 years. In fact, Your Honor, he did the trials, has the same alleged victim on his brother as well, so he's very familiar with the case, and I would love for him the opportunity to be involved in this case. If we have to wait a few more months to that, I think that's what I think we asked for tonight.
We're not waiting. I'm not waiting. Technically, I have every right to dismiss this case. The people will reissue, and I understand that people have additional charges if they reissue that they're going to do. I don't know that that's in anybody's best interest, but I'm happy to do that. I can dismiss today, and you can reissue with a whole lot more problems. And this case is too old. It's old, it's ancient, it's going to trial. I'm not waiting for Mr. Silverthorne because I have waited for Mr. Silverthorne multiple years because of his multiple health issues. I have given him grace. I've given your office grace. I've given defendant grace. no more, we're done, because there is no guarantees coming back in April. There will be no more delays in this case. This is a 2020 case. We are in 2026.
So it's just to further add, you know, and I have the utmost respect for Mr. Silverthorne, and Mr. Feigelson. Unfortunately, Mr. Silverthorne over the last couple of years has had, some issues that have required his absence. And, you know, at this point, the last I spoke with him in December about this case, I had no idea about this issue that was forthcoming that has caused this delay in the trial. You know, originally he was going to be back in early February. That's clearly not the case. Now allegedly it's April. I heard 2 days ago it was going to be summer. So, you know, and my fear is that we wait for Mr. Silverthorne to come back and then there's going to be another reason for a delay. This case needs to be tried. The people are ready to proceed to trial. It's time for a jury to hear this case.
And as we always say in our business, justice delayed is justice denied. It will no longer be acceptable for delays on my docket for this case. There's no good reason. What else do we need to discuss? Because I also understand that, which I was not aware of, that the district judge gave a very low bond, no tether, no nothing in terms of not even reporting to pretrial services. And this is a capital case. So, sir, I don't have any new charges. I don't know exactly what's going on here. It doesn't look like you have violations, but how would I know that? Because pretrial services is supposed to monitor you. So if you would like to remain out on this ridiculously low bond on this kind of case, I am modifying bond. The bond modifications include that you'll report to pretrial services as directed by pretrial services weekly. So they may have you come in person, they may have you on Zoom, they may have you on telephone. I don't know, it's up to them, but you'll report weekly. You will be on a jail GPS tether with victim notification if victim's address is known. You shall not use, possess, consume, purchase, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. You will not be within 2,000 feet of victim's work, school, residence. You end up at the same Myers, you do an about face and you leave. You end up at the same church, you do an about face and you leave. You don't signal her, you don't say anything, you don't wiggle an ear, or you'll be in violation. You'll show prescriptions for all medications from a licensed medical physician to pretrial services within 24 hours. Take any psychotropic medications, if any, as prescribed. You'll follow all doctor's recommendations. You can use over-the-counter medications as labeled on the bottle. You can use less but not more. You will PBT and or drug test as requested by pretrial services, law enforcement, any court officer, or any adult you live with. And you'll not adulterate any test. You will not own, have in your possession, or under your control any weapon, gun, ammunition, imitation of a weapon. You'll not be in the presence of anyone who has those items. You go to a friend's house or relative's house, they have a gun, a sword, whatever it is, you just do it about face and leave. They may not get in trouble, but you will get in trouble. You will not be in the presence of any known gang members. You'll not wear any gang colors, gang insignia, or gang tattoos. You will maintain your current residence, and any address change will be reported to pretrial services, the court, and counsel within 24 hours. You will have no contact with any minor children unless supervised by their guardian. You will appear in court for all hearings and proceedings. The next court date, we have motions scheduled February 26th at 9:30. It's technically at 9:30 and 11:30, so it's planning on spending the morning in the courtroom. And the trial will be March 9th at 9 a.m. You will not have any contact with Tiffany Bristol, the victim, or any witness. You will allow pretrial services into your residence to check your phone, home, garage, and computer for any violations based on reasonable suspicion. Is there anything else I need to add?
Your Honor, as part of this case, I anticipate the testimony at trial is going to be that this defendant threatened the victim with 2 katanas, saying he would cut her fingers off if she told anyone about the sexual abuse. He also had a gun that is registered to him that he would wear a holster and have on his hip, though I don't believe there are any direct threats to the victim involving the gun, there may have been motions with the gun, and the fact that he was wearing it certainly scared the victim. I would ask that because there's a condition of bond now that he not have any weapons or firearms, that he turn those into the Michigan State Police. The ones I know about are the 2 katanas and the firearm that's registered in his name.
Judge, my understanding that the firearm's been removed a long time ago, and the firearm's at your brother's house, is that correct, Mr. Gupp?
That's correct.
Where are they?
They're at my brother's house.
Okay, he can turn them over to MSP, because the problem with your brother is you can go over to your brother's house and get it anytime. So I don't know if your brother will turn it over or not, but I don't have jurisdiction over your brother, so I can't really order your brother to do anything. I can order you to go retrieve them or allow someone to retrieve them, but the weapons are all going to be turned over to MSP. And I understand that katanas, there's some pictures. I haven't seen them, I don't know anything about it, but they'll be used in evidence. So that evidence needs to be turned over to MSP. And they'll take care of your weapon. If you are found not guilty, your weapon will be turned over to you.
Your Honor, I'll get with Mr. Feigelson to see how they want to arrange that in terms of either him taking them to MSP or me having the detective.
They'll be turned over within 72 hours. That's all you got.
Okay.
All right, anything else?
Your Honor, let me go ahead and put the plea offer on the record, if that's all right with you. And this has been the plea offer for a long time. When I came on the case, I told Mr. Feigelson that I was willing to keep this offer open. The plea offer would be for the defendant to plead guilty to count 3, CSC second, and then the added count 4 of child abuse first. Upon successful plea and sentence, people agree to dismiss counts 1 through 2, which are the CSC first with a mandatory minimum 25 years if convicted. We would dismiss counts 3 and 4 would run concurrent to each other. The people agree not to charge the defendant with possession of CSAM or aggravated possession of CSAM, or using a computer to commit a crime for the 88 images that were found on his hard drive.
Images?
Oh, sorry, the 88 images, 88. Number 8.
Yeah.
88.
Oh, 88. Thank you.
And what's the date range of that? Do you know?
The date range of
The CSAM, those 88 images.
I don't have that offhand, Your Honor. It's
Okay.
Word.
I'm sorry, you went a little fast. The child abuse, is it 4th or what? What degree?
First,
Okay, got it. Thank you.
the defendant agrees to forfeit all devices seized as part of this investigation. Sentence agreement, fixed minimum of 10 years in Michigan Department of Corrections, judge to set the tail, must comply with SORA. I'd also just like to place on the record the benefits of the people's offer. The defendant wouldn't have to face the 25-year mandatory minimum when convicted, which applies to counts 1 and 2. Your Honor could consecutive sentence him on every single count, including count 1 and 2, be arguably 25 years plus 25 years plus 3.5 to 7 years if you do bottom of the guidelines. That's 53 years on the minimum before he would become eligible for parole. He doesn't have to leave his fate up to Your Honor. And Your Honor previously heard the trial against his brother and sentenced his brother, I believe, to the max. He would be able to get out of prison instead of spending the rest of his life behind bars. He wouldn't have to face hundreds of additional counts for the CSAM found on his hard drive. So each of those 88 images could be a count. Each of those 88 images would also have an additional count of using a computer to commit a crime. That would be up to 176 additional counts.
Is that full, fair, accurate, and complete?
It is, Your Honor.
Sir, do you understand the plea offer?
I do.
I believe this has been conveyed before.
Yes, I have.
And is this something that you would like to take or think about?
I'll decline it.
Okay, Anyone force, threaten, or coerce you to decline?
No,
Anyone promise you anything that caused you to decline?
no,
And you understand this is not going, this offer will not rise again. We're done, we're going to trial.
I
You
understand.
understand
yes,
that? Okay, and you understand that if found guilty, I don't know what I will do. But I can tell you it's gonna be more than the 10 years minimum.
okay,
But they, or maximum that they have. I mean, because I think by statute it's 25 year.
Correct.
So I don't have any choice in that. So, you understand that? I can't, your attorney can do the finest job on the planet in terms of trying to argue me down, but the statute's 25 years, so that's where that comes from, you understand?
I understand.
Okay, and you've made this decision of your own free will?
I did,
You've talked about this with Mr. Silverthorne, correct, previously?
in the past, yes,
Yes, and with Mr. Feigelson,
yes,
and you've been satisfied with the representation of Mr. Silverthorne and now Mr. Feigelson?
yes.
Today? All right, so we're going to trial. We have the next 2 dates. Is there anything else I need to address?
Your Honor, you should probably go downstairs to check in with,
Yeah.
Pretrial Services.
Judge, I'd like to make an additional record.
You may.
Mr. Goff, we talked about that offer last week, is that correct?
Yeah.
We also talked about that offer yesterday at my office, is that correct?
Yes,
And as well as out in the hallway today, is that correct?
yes,
And I did advise you, well, that you should consider that offer, is that correct?
that's correct.
And after hearing all of that and hearing everything today, you still wish to reject the offer, is that correct?
Yes,
And you are where that has been revoked and there will be no offers, is that correct?
that's correct.
And you understand the risk that you face if you're convicted by a jury, is that correct?
Yes,
You still wish to go forward, is that correct?
yes,
No additional question.
Thank you. And let me just explain to you, sir. I don't take pleas on the date of trial because when that happens, you have taken away somebody else's right to go to trial. So in order to keep the docket moving and get everybody's case heard, I have to have these cutoffs, and that's why this is happening. Do you understand that?
yes,
All right, but regardless, you've had enough time and it's always been your desire to go to trial.
yes.
All right, court is satisfied. Please go down to pretrial services.
I'll think that.
Thank you. Go for the record.
Davion Forest next.
This is docket 25-3250 FC, People of the State of Michigan versus Davion Forest. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Luxon on behalf of the people of the state of Michigan, stepping in for the prosecutor on this case, Bill Prino.
Good morning to this honorable court. Carla Marable, P number 62755. On behalf of Mr. Forrest. Mr. Forrest, please state your full name.
Davion Marquise Forrest.
Thank you. Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. And have you taken any medication yesterday or today?
No, Your
Are
Honor.
you supposed to be on medication you're not on?
No, Your Honor.
Okay, you don't have to keep leaning forward, or you can move the microphone closer to you. I think we're picking you up. All right, any sign of fever, COVID, or other illness?
No, Your Honor.
And have you had enough time to speak with your attorney?
Yes, Your Honor.
All right, thank you. And counsel, what are we doing here today? This is a final pretrial, correct?
Yes, Sean, I was able to try to talk to Mr. Grail. And I think that we have another pretrial set for May.
No, we don't. Why do we have another pretrial set?
Your
Final
Honor.
means final. Is there a second final?
Your Honor, this is the case that I'm sure you remember last week. There were the multiple co-defendants for this case. We are still awaiting the transcript from district court, and there are other negotiations going on, as this is a case in regards to a potential murder, Your Honor. So all of the co-defendants were moved to a status conference on May 20th, 2026.
All right, May 20th, then that is the final. There's no more moving it. And I understand, but that's a final pretrial. Weren't there going to also be motions? Have those been set?
I'm not sure if those motions have been set at this
Are
point.
you
Your
aware
Honor.
of those?
Your Honor, if I may chime in, I represent one of the co-defendants.
Your appearance counsel.
May it please the court, David G. Carter Jr. We set this for a status conference control date of May 20th because we're still waiting for transcripts from the district court. There's also some evidence that has been come to the prosecutor's attention that has not been released because of some sensitivity, and he's got to go through that yet. So that hasn't even been released.
Yes.
So what we did is we scheduled this for a May 20th status conference because it's a very complex case with 5 defendants.
So, and I'm gonna verify with the district court that we get those transcripts. I think that we have that note. I just have been in a homicide trial, not time to do anything. But nonetheless, what about the motions? I know there were going to be motions filed. Are those going to be filed before the 20th? And
We don't know because of the transcripts.
Transcript.
That's a very important thing. And then we have this new discovery that's coming in, and then there may be some some joinders for 3 of the defendants and joinder for 2 of the defendants. So there would be 2 different there's a lot of things going on, and we're not ignoring the case. We're actually working through it.
all right, so May 20th, at what time did we set?
At 1 o'clock.
All right, I'll see you then. Serve bond and bond conditions are continued. Is there anything else, counsel?
No, y'all.
All right, have you been in contact with district court in regard to the transcripts?
Yes, we did order the transcripts, and I don't know what's going on.
And I'm
with the
asking, have you followed up?
Yes, there was a follow-up last week, Your Honor, with one of the other defense attorneys.
Okay, and who was the judge on that? Do you know?
I can double check, Your Honor. I believe it was Simmons.
Judge Ward?
Oh,
Yeah.
Ward? Was it Ward or
Simmons?
Simmons?
It was
Oh, Ward. Okay.
Ward, yes.
Okay, I'm gonna make a call too. All right, thank you. That's
Thank
all for
you.
the record.
See you May
Bond
20th.
conditions
Thank
are
you.
continued, yes. Next matter.
We're gonna do Amanda Barkowiak. Never mind, we're not doing that. We are going to do Arnold Montrese things.
Latrice Arnold.
Sorry, yeah, Montrese Arnold, guys.
Oh, okay. I'm looking for it. All right, this is docket 25-3055 FH, people of the state of Michigan versus Montrese Arnold. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barb Buxton on behalf of the Eagle State of Michigan.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Arnold, who is standing to my right.
Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with Mr. Goodrich?
Yes, ma'am.
And on behalf of the people, there was an offer, is that correct?
That is correct, Your Honor.
What's the offer?
The offer in this case would be a plea to an added count 3 of aggravated domestic violence. That is a misdemeanor punishable up to a maximum of 1 year. If the defendant were to move forward with that plea, then count 1, the aggravated or the assault with intent to commit great bodily harm less than murder, and count 2, the domestic violence 3rd, would be dismissed, as well as the habitual offender's 2nd. Guidelines I have, if the defendant were to go to trial, Your Honor, are 5 to 28. And obviously, if the aggravated domestic violence, there would be no sentencing guidelines. My understanding is that Mr. Arnold does not wish to take that plea and move forward with trial. That is set for February 27th.
Is this full, fair, accurate, and complete?
That is full, fair, accurate, and complete, Your Honor.
Sir, full, fair, accurate, and complete?
Yes, ma'am.
And on behalf of the people, the victim was consulted with this offer?
The people have complied with the victim rights advocate statute, Your Honor.
Thank you. And so, sir, you wish to go to trial?
Yes, ma'am.
And you understand that assault with intent to great bodily harm, less than murder or by strangulation normally is a 10-year felony, but with habitual second, it is up to 15 years. And the guidelines are 5 to 28. I have not heard your case. I know nothing about your case. If you were found guilty, I do not know what I would do, whether it would be jail, prison, or probation. So you understand you're taking quite a risk.
Yes, ma'am.
And you wish to go to trial.
Yes, ma'am.
Did anyone force, threaten, or coerce you?
No, ma'am.
Anyone promise you anything that caused you to make this decision?
No, ma'am.
You've made it of your own free will?
Yes, ma'am.
After you've discussed everything with Mr. Goodrich and looked at the evidence and all your options?
I haven't looked at any evidence, but I discussed it with him about going to trial.
Okay, but I'm sure Mr. Goodrich has told you what they have or don't have, that kind of.
Oh,
thing,
okay,
right?
yes, ma'am.
Yeah,
Yes, ma'am.
okay.
Yes, ma'am.
And so, and you've been satisfied with the representation of Mr. Goodrich?
Yes, ma'am.
All right, I'll see you at trial. If we're satisfied, unless you'd like to make further record, Mr. Goodrich.
Your Honor, I would just state it, it's my understanding that we're not first on the list for that date, but we're not all that far down the list. So we will be
That's
prepared
correct.
for that date.
And if you're not, if you don't go that date, we will give you another date very quickly.
All right, thank you, Your Honor.
All right, bottom line conditions are continued. Thank you.
Attorney Jeremy Theodoro next.
Judge, if it's all right, if I could step up with a minute with Mr. Theodore to confirm how we want to proceed.
Great.
Sign.
Get it over with.
Brian, I think.
Yeah.
Grab the copy.
I can give you a copy of this stuff, yeah. Your Honor, may we approach?
You may.
That's how many I get.
Oh, Judge, this is gonna be a no contest plea. I have some documents already prepared and highlighted, if I may approach.
You may, is this based in civil liability?
It is, Your Honor. So I'm gonna call, just to be clear, I'm gonna call the court's attention to the highlighted portions indicate the complaining witness's name and date of birth, which give age for the factual basis. That's on page 1 of the report I'm going to hand the court, and then page 6 of the report indicates the factual basis is highlighted, but it's under Aaliyah Naranjo's statement, and that indicates the factual basis for the plea, if I may approach.
Did Nancy, did I call the case?
You did not.
Okay, great. Okay. This is docket 24624 FC, People of the State of Michigan versus Jeremy Scott Theodoro. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Jeremy Theodoro, who's standing to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down, sir. This is going to be a plea. Have you had enough time to speak with your attorney?
Yes.
Have you taken any medication yesterday or today?
No.
Are you supposed to take medication that you're not on?
No.
Any sign of fever, COVID, or other illness?
Not that I know of.
And when you're not in custody, do you live on South Park Boulevard?
No.
Okay, do you have an address?
No.
Okay, and did you graduate high school?
GED.
That's good, okay. On behalf of the people, I understand there's going to be a plea today.
So that is correct, Your Honor. The plea,
Just a minute. And sir, were you on probation, parole, or bond conditions on any other file?
No.
Okay, I mean during the time, whatever you pleaded to, you were not.
No.
Okay, very good. And you're a US citizen?
Any what?
You're a US citizen?
Yes.
What is the plea agreement?
Your Honor, the plea agreement would be to an added count 3 criminal sexual conduct in the 3rd degree. Upon successful plea and sentencing, the remaining counts would be dismissed. This will be a no contest plea due to civil liability, and there is a Killebrew agreement to a 60-month county or 60-month cap on this case.
So 60 months on the minimum.
Yes, Your Honor.
Well, it's a cap, so I think it's 60 months. Yeah, yes, 60 months on the minimum would be the cap for the sentencing, yes. It was confusing when you said that, because at first I thought you meant 60 months would be the maximum penalty, but,
No,
but, right.
Yeah.
The minimum sentence cannot exceed 60 months.
Yeah.
Correct.
Thank you. And victim was consulted?
Yes, Your Honor, the victim rights statute has been followed in this case.
Full, fair, accurate, and complete?
Yes, Your Honor.
Full, fair, accurate, and complete? And counsel, are you waiving reading, counts 1? And, well, I guess one was dismissed at preliminary examination, you're waiving reading count 2. And
Yes, Your Honor, I'll,
visual, I don't have it in front of me, wait a minute, the visual, we're waiving reading count 2, count 3, and the visual 3rd.
that's accurate, Your Honor. We're waiving reading of anything that he's not pleading to.
Okay, so this will be an added count 4. All right. As to the reading of the felony information,
Yes, Your Honor, this will be an amended felony information that will be submitted after this hearing. The people of the state of Michigan versus Jeremy Scott Theodoro, State of Michigan, County of Ingham, in the name of the people of the state of Michigan. The prosecuting attorney for this county appears before the court and informs the court that on December of 2023 at 553 South Park Boulevard, the defendant in an added count 4, criminal sexual conduct, 3rd degree, person 13 through 15, did engage in sexual penetration, to wit, penis/genital opening with a child who was at least 13 years old but under the age of 16, contrary to statute. SORA notice. This is a tier 3 offense under the Sex Offender Registration Act, or SORA, unless the court finds that the victim was between the ages of 13 to 15 inclusive, consented to the conduct, and the defendant was not more than 4 years older than the victim. Under MCL 28.722 subsection 5 subsection 4. HIV/STD testing notice. Take notice that pursuant to MCL 333.5129, upon bind over to circuit court or recorder's court, district court judge shall order the defendant to be tested for sexually transmitted infection, hepatitis B infection, and for the presence of HIV or an antibody to HIV if the judge determines there is reason to believe that the violation involved sexual penetration or exposure to a bodily fluid of the defendant. If the district judge determines that testing is not required upon conviction, the court must order the defendant to be tested. This is a felony that's punishment up to a maximum of 15 years with mandatory AIDS/STD testing as stated previously. Court shall order law enforcement to collect DNA identification profiling sample before sentencing or disposition, if not taken at arrest, and against a piece of AB of the state of Michigan.
sir, did you understand what was just read?
Yes.
So you understand CSD 3rd, person 13 through 16 is a felony punishable by 15 years. You will also be required to give your DNA unless it's already been done and undergo the STD, hepatitis, HIV testing. You understand all of that?
Yeah.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes.
Did you understand what you read?
Yeah.
If you had any questions about your rights, we were able to ask those of Mr. Palmer.
No.
You didn't have any questions?
No.
Okay. Well, you had an opportunity to talk with him and you could have asked questions if you had any. Is that correct?
Yeah.
Do you have any questions about your rights in this court?
No.
Sir, as to count 4 on the amended felony information, criminal sexual conduct, 3rd degree, person 13 through 16, how do you plead?
No contest.
Based on civil liability, is that correct, sir?
Yeah.
And sir, you understand ultimately, even though you pled no contest, it has the same effect of a guilty plea. You'll be under the jurisdiction of this court.
Yes, I understand.
All right, and sir, did anyone force, threaten, or coerce you to plead?
No.
Anyone promise you anything that caused you to plead other than the plea agreement?
No.
Has anyone told you what I will do at sentencing, other than the plea agreement?
No.
And you pled after you talked about everything with Mr. Palmer?
Yes.
And you pled of your own free will?
Yes.
And you've been satisfied with the representation, Mr. Palmer?
Yeah.
And you understand by pleading, you are giving up certain rights and defenses you would have had you had a bench or jury trial, such as the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense or not, etc. You understand you're giving up those rights?
Yeah.
And you understand you're also giving up an automatic right of appeal. If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal. Had you had a bench or jury trial, didn't like anything, the Court of Appeals must take a look at your unhappiness, but now it becomes their choice. Do you understand that?
Yes.
Now, there is what we call a Kilburn, that's an agreement between all of you, I'm not involved in that, but if I don't follow that, for example, if I gave you more than 60 months, I would allow you to withdraw your plea, and this matter would again go to the pretrial stage. Do you understand that?
Yes.
However, if you violate bond conditions, the law, there's new charges, allegations, then I don't have to follow this agreement, and I don't have to allow you to withdraw your plea. Do you understand how that works?
Yes, I understand.
Court has been provided by stipulation, the Lansing Police Department case report 245-190-2117. The victim, I'm not going to say her name because she is a minor, but was at the time of the investigation, the allegations made 15 years old. She has a May 19th, 2008 date of birth. It does appear that this offense occurred on or about December 2023. Well, that's what the found information says, but the police report includes an interview from Small Talk, but it looks like the offense was March 19th, 2024. Oh, that's when she was interviewed.
That's the interview date,
Do
Judge.
you have somewhere in here the date? Or what counsel stipulate to the date?
I will stipulate to the date, Judge. I think that the issue was, it was in December of 2023. The specific date, whether there was a couple of days where the complaining witness, or the victim, I guess I should say now, where we're entering a plea, couldn't nail down a specific date. It was directly before Christmas was what was indicated at both the interview and the preliminary examination.
Okay, great. And she's not required to have a specific date, but
Agreed.
this, want to make sure that everything matches out.
I agree, Judge. We'll stipulate to the date of offense being in December of 2023.
Thank you. On behalf of the people, so stipulated.
So stipulated, Your Honor.
Great. The forensic interview included that the victim was awoken by defendant being on top of her. She attempted to get him off of her, but she couldn't. She recalled being very tired and she couldn't feel him inside of her. She defined being inside of her as his penis was in her vagina. The father of the victim stated that he was made aware of a possible sexual relationship that was occurring between his daughter, who was 15 years old, and his 34-year-old friend, Jeremy. I don't know that we need more than that.
People are satisfied, Your Honor.
I was gonna say the defense is also satisfied, Judge. I don't know. May I approach?
You may. Thank you. I'm handing counsel back the police report.
Thank you.
Thank you. On behalf of the people, are you aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Counsel, thank you. This court comply with the court roll.
You have, Your Honor.
Yes, Your Honor.
I find defendant pleas are freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there is sufficient grounds to accept defendant's plea. And sir, you understand this is a tier 3 offense and you'll have to register under SORA, comply with all rules.
Yes.
All right, thank you. I find there is sufficient grounds based on the interview and the investigation of law enforcement and in the police report, as well as the stipulation of counsel. Therefore, count 4 will enter. And counts 1, 2, well, count 1 was dismissed at preliminary examination, so count 2 and 3 and the visual third offense notice are dismissed in their entirety, along with any outstanding warrants related to this file, if any. Do we have a sentencing date?
April 8th at 10:30.
Does that mean, well, counsel, you are
Judge-
sadly moving on?
I am moving on, Judge, just to be clear, and I've already made my client aware of this, the sentencing will be handled by Stephen Feigelson from my office. I'm looking at his schedule and it appears that he has to be here that morning, here at the circuit court, that is, that morning anyway, so I will add it to his schedule.
And he's here. All right.
Oh, he's here. Sorry.
For some reason, I need to check my schedule. I think I might not be available the 8th, but if it's not the 8th, it'll be moved to the 15th. Let's just move it to the 15th.
I think I'm here on the 15th
He's-
as well, yeah.
Yeah, I was gonna say, he's also here on the 15th.
Okay.
So it's April 15th at 10:30?
Yeah, let's do the 15th. What time were you here on your other case? Do you know?
He's here at 8:30 on the
Yeah.
15th.
So I
Well,
think
I'm not
that's
here at 8:30, so I'm gonna schedule this for 9:30.
good enough, 9:30.
So you must be here for a pre-trial then.
Yeah, I think I'm in another courtroom, but. on
I
this
got
phone,
it.
yeah.
Okay, so 9:30 or 10, whenever you're done.
Yeah.
Okay, just keep us posted. Sir, you'll need to keep an appointment with probation. They're going to come and see you. And we're going to then all have a copy of a pre-sentence investigation report that we discuss at sentencing. So they'll come and spend some time with you, and the report needs to be accurate, so make sure you give them whatever information they need. Are you getting what you need, Jeff?
Yeah.
All right, bond is revoked. Is there
Understood.
anything else?
No, Your Honor, thank you.
I'm sure I'm revoking bonds, so all your time counts. All right, anything else we need to address?
Does he need the STI?
Yes, he also needs the DNA. Did they swab you or is you have prior, so your DNA is probably in file. Okay, so he doesn't need the DNA, but he needs the HIV testing. And we'll also order that testing, so, all right?
Yeah. Understood, Judge. Thank you, Your Honor.
Thank you, that's all for the record.
Amanda Bartkaliak next.
She's here on Zoom now. I did meet with her earlier today.
All right,
Four
good. Mhm. All right, this is docket 25-6246 FH, People of the State of Michigan versus Amanda Bartkaliak. Ma'am, if you could unmute yourself and put your camera on.
It won't let me turn the camera on, but I'm unmuted. Oh, wait, there it goes.
I don't
have that second check, Joe, so I don't know why.
Okay, she's,
Got it.
all right, good. Thank you. Counsel, your appearances for the record.
Good morning, Your Honor. APA Bart Bucks on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, on behalf of Amanda Bartowick, who's present by way of video conferencing, Your Honor. She's at Glass House today.
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
I do.
All right, you may put your hand on. Are you, I see your hand is bandaged there. Are you taking any medication?
Nope.
All right. Are you supposed to be on medication you're not on?
Nope.
Any sign of fever, COVID, or other illness?
Nope.
And you don't need to tell me what's wrong with your hand there, but, are you in pain so much so that you won't be able to pay attention, or are you okay?
I'm in pain, but not that bad.
Okay, so you're gonna be okay to proceed today?
Yes, I am.
Okay, good. Have you had an opportunity to speak with your attorney and review the pre-sentence investigation report?
Yes, this morning.
Okay, do you need more time with him?
No, I'm good.
If at any time you do need time with him, just let me know, okay?
Okay, thank you.
All right, and counsel, we all stipulate that she is okay. I think we talked about this at the time of sentencing, that she's okay reporting on Zoom, correct?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. On behalf of the people, any corrections, additions, solutions?
Not to the body of the report, Your Honor.
Counsel?
Yes, just one change, Your Honor. It's gonna be in two places. On the first page of the report, where it says personal history under where employed,
Yes.
she still works for the National Gardening Services, Your Honor.
National
Garden Services, Your Honor.
Gardening?
Garden.
National Garden Services.
Yep, on page 8 of the report, it lists when she started working there. Although she did leave the employment on the 18th, I believe she does still have that job. I think they were on furlough, and I think when she gets out of Glass House, she'll be able to return there, so she still is employed there.
I'm just gonna make a note under employment, still employed. I'm just gonna strike arrested, so I'm just gonna be still employed. That's okay. All right. Any other corrections, additions? If not, as to the guidelines.
I had no other changes to the report, Your Honor. I do believe there's stipulated changes to the sentencing guidelines, Your Honor. Either myself or Mr. Buxton can place that on.
All right, let's proceed with those. Is that correct, counsel?
That is correct, Your Honor. In regards to PRV2, it is currently scored at 20. However, I believe that probation did not take into account the 10-year gap in the defendant's criminal history. So both parties stipulate that PRV2 would be scored at 0.
PRV2 is now 0 by stipulation.
And then additionally, Your Honor, PRV5 should be scored at 2 points, as she still had one misdemeanor that would have been within those 10 years, but not the remaining.
But not the what?
Remaining.
PRV5 is 2.
Correct, Your Honor.
That would make the total PRV 7, Your Honor, and change the PRV level to B.
And the minimum?
That would then change the guideline minimum range of 0 to 9.
So stipulated?
Yes, Your Honor.
All right. And did you have any other corrections? Because otherwise I will make these corrections on the basic information sheet.
Not from the people, Your Honor.
Nothing else on behalf of Ms. Bartowicki, Your Honor.
All right, I've made the correction on the basic information sheet. I'm looking in the body because sometimes they. Yeah, under recommendation area, I'm changing the 17 under the range to 9. And then it looks like everything else is consistent. Okay. On behalf of the people, what would you like me to know?
Yes, Your Honor. I understand that the recommendation by probation is 365 days. However, with the change in the guidelines, obviously, the guidelines are 0 to 9. I do believe that that the defendant should serve 9 months. However, those be in abeyance so she can attend TRICAP. I believe TRICAP would be appropriate given the case as well as her criminal history. So I would ask that you follow the recommendation in regards to that. Thank you.
Counsel?
Yes, Your Honor, with regards to the recommendation, I do believe probation will be appropriate here, Your Honor. Miss Bartlett is at Glass House right now. She is in the process of starting her treatment there. And I believe, given the circumstances, that's probably the best place for her to be. I know probation is recommending TRICAP, and although I do believe in that programming, I think having her continue at Glass House and whatever other aftercare they advise from there is appropriate. And if at that point, the treatment team there believes that TRICAP or another residential programming would be beneficial, then they can order that. But I think I'd like to have her to continue at Glass House.
Did she choose Glass House or did someone else put her there, or do you know how she got there?
I know she was at the Ingham County Jail, and I don't know if that was something that her and the CATS folks determined.
Okay.
Do you know, ma'am, how you got to Glass House?
I had spoke with the cats about it. I originally wanted to go somewhere far, but then my mom ended up with 2 heart surgeries, so I chose somewhere where I could be close.
Okay, so how are you doing at Glass House?
I'm doing great, actually. I like it here.
Okay, what else would you like me to know, ma'am?
That I'm actually, I want to be sober. I got to get out and take care of my mom. I can't do that messed up.
All right.
And I'm doing it for me. I'm not doing it because I'm ordered here. I wanted to come here.
All right, good. I'm gonna place you on 24 months probation. You shall follow all the requirements of testing and treatment, sign all necessary releases, not have any drugs, alcohol, drug paraphernalia in your presence or under your possession or control. You will complete Glass House, and if you are positive after that, you'll also complete the aftercare that they recommend. However, if you're positive after that, you will immediately be placed in TRICAP.
Okay.
As part of your treatment, I believe both Glass House and TRICAP are cognitive based, so you'll be required to undergo individual and group therapy that includes cognitive behavioral.
Yep, I already do that.
And what about your residence? I have that you live on Bellevue. Is that where you'll return when you're done?
No, I'm gonna still continue at my uncle's at 4948 Deer Run Lane, which was my original address, because my mom's in a nursing home right now and I have to get her out of there. So until I'm able to get out and get stable, I will be moving with my mom, getting her out of the nursing home because I promised she'd never be there.
Okay. And I'm sorry, what's the lane, Deer?
Deer Run Lane. Deer Run. Yep.
Yep.
Holt, Michigan.
Holt,
nope,
okay.
That's Holt. 48842.
Okay. You will not change your residence without permission of probation in the court. You'll obey all court orders, all recommendations from all treatment providers. Those become orders of this court. You will not have verbal, written, electronic, or physical contact with anyone who's on probation or housed in the Michigan Department of Corrections without permission of probation. That does not include those people who you are in treatment with. But when you are out, you'll not associate with those people. If there's some reason that you need to, then you will get permission from probation. You'll contact probation within 24 hours of your release from Glass House. You'll comply with all written and verbal orders of probation and all treatment providers. As I said earlier, those become orders of this court. You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer without the need of a warrant of probation as reasonable cause to believe you violated the conditions of probation. You must report any arrest or police contact, personal protection order placed on you, loss of employment or change of residence to probation within 24 hours. Weekends and holidays are accepted. So if something happens on a Friday, tell us on Monday. If Monday's a holiday, tell us on Tuesday. Ma'am, have you taken any medication today or yesterday?
No, I
All right,
refuse
very
to take them.
All right, very good. And your work, is it full-time? Are you working at least 30 hours per week?
What I am, well, my shifts can go from, I have to be at my first store by 10:30 a.m. and off the floor by 8 p.m. I have 3 different stores, which I do all the flowers outside of Kroger's. So my hours vary. It could be 15 to 20 hours to 60 hours. It just depends on if we get shipments in and what I have to do. And right now we're off till basically the end of March to April. It depends on when our first set of ferns come in.
So do they pay you while you're off? Do you get like
Nope,
unemployment?
No, I can file for underemployment, but I don't do that. That's
Okay. Well, as long as you can survive on that, that's fine. Otherwise, you might need to get a different job or a second job.
Yeah.
Okay, you'll not give your employer any cause to terminate you. I'll allow you to keep that employment, even though it's not 30 hours per week. Sounds like you're doing well and you enjoy it.
I've been there for 4 years. I'm union. I got a 401k going, so and I get paid to travel and play with flowers.
Okay, so I'm gonna say that you can keep your current employment regardless of hours, which will not give your employer any cause to terminate you.
Yes,
You'll serve
ma'am.
365 days jail with credit for 5 days. The balance is held. You will pay $130 crime victims and a $68 state cost, and that won't be due until the end of your probation, so you basically have 2 years to pay that. I'm waiving probation or oversight, finding that you are indigent.
Thank you.
And I'm also waiving attorney fees, finding that you're indigent. You
Thank
will
you.
not engage in the recreational use of marijuana or alcohol, and if you have the need for either one, you'll get a prescription from a licensed medical physician and only use as prescribed. You will not use any objects as a weapon, no guns, no ammunition, no imitation of a weapon. You'll not be in the presence of anyone who has those items. You have
Yes, ma'am.
42 days to appeal and to request appellate counsel. Mr. Feigelson, you'll mail that to her with the proof of service to the court.
Yes, ma'am.
Anything I missed?
No, Your Honor.
All right, good luck to you, ma'am.
Thank you for giving me a chance.
Well, thanks for walking through the door and taking the chance. Not everybody does that, and I'm glad to hear that you're doing that for you, because that's what matters, man.
It does. It does make a difference, and I know that.
All right, thank you. That's off the record.
Thank you. Have a blessed day.
You too.
Should we do Judge Stokes in our courtroom or we don't have that?
Either way.
We're gonna have to clear the courtroom for the next hearing.
All right, anybody not associated with the next hearing needs to step out for just a few moments, and then we'll return. We have a confidential matter to handle.
his attorney?
He's not have an attorney for now.
Is it Mr. Kaplan? It's not Mr.
No, it's not Mr. Kaplan.
Because he, I just thought.
No, Mr. Kaplan's on another,
Okay.
11:30.
Our stuff.
All right, this is docket 23440FH, People State of Michigan versus Edgar Rivera Perez. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barbucks on behalf of the people of the state of Michigan.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
You may put your hand down, sir. You were placed on probation after you pled guilty to interfering with electronic communications, punishable by 2 years, domestic violence, punishable by 93 days, and operating while intoxicated, third offense, punishable by 5 years. Do you recall that?
Yes.
And Dwayne Silverthorne is your attorney. However, he is not available, and they should be appointing you another attorney.
Your Honor, I can clarify. So my understanding is this, that Mr. Rivera Perez will be hiring, or is in the process of hiring Mr. Robert Ochanicki. He is apparently representing him on the misdemeanor matter. Us as well as me as well as your court staff received an email from him stating that he is likely not going to be present today. He was going to try to be here, but he said, quote, "Don't wait for me, I will probably be too late." So he said that we can just arraign him at this time. I know that he would be requesting an adjournment on the matter, so one, he could be present, and two, as the charges, the probation violation is in regard to new charges, he wanted some additional time to move forward on that case. Court dates on that case, Your Honor, just so you're aware, there was a pre-trial on the 9th, so earlier this week, and then it is set for a final pre-trial on April 13th.
Okay. Sir, I have a bench warrant for the alleged violations as follows. And I believe this applies to both files. On or about July 27, 2025, defendant displayed assaultive, abusive, threatening, or intimidating behavior toward Catherine Ramos-Martinez. And that is the violation. I suspect the new charges stem out of that. Is that correct, Mr. Kukowski?
That's correct, Your Honor.
On this probation, has he completed anything?
He has, Your Honor. Mr. Rivera Perez has done well with probation. He is enrolled in CBT individual counseling. He's completed his assessments. He reports to probation on time as instructed. When he does not, he does communicate well. He has continued to be employed through legitimate employment as well as self-employment throughout the probation term. If I can give you some of what is actually going on here, what I, as stated, has been dealing with. Him and his child's mother, who is the listed victim here, have serious back and forth, even between myself and them. I've had many serious discussions with them about severity of his probation term as well as the court and the court's time. And that's kind of what I've been dealing with with this situation over the last
Okay.
almost 24 months.
Other than that new allegation, he's been compliant.
He has, Your Honor.
He's been on probation almost a full 2 years.
Correct.
Dismiss this successfully. I'm withdrawing this violation. We've got another file to deal with. There's no reason to keep this open.
Understand, Your Honor.
You'll be released. How much jail time does he have on this?
He has a total of 323 days served.
So he gets 323 with credit for 323 discharged successfully. You'll have to deal with the other case. Okay with you, sir?
Thank you.
That's all for the record.
Thank you, Your Honor.
So Mr. Kaplan, is the AG on here as well?
I don't know who the AG is, I don't.
It's at 11:30, so I don't know.
Is there an AG on Zoom?
Okay,
Well, there is Mr. Kaplan's on Zoom.
yes, I see Mr. Kaplan, but I don't see the AG, and that's an AG case that Mr. Kaplan's here on.
Okay, which case is it?
That's Jeffrey Harrell.
Correct.
Okay, well, that's scheduled for 11:30.
Yeah, I just saw him on Zoom, so I was trying to get him in and out if the AG was here, but that looks like they're not.
Okay, well, let's take another one while we wait for the AG, and then we
We
can follow
will.
up to see if he even knows that he's supposed to be here.
Let us do Jordan Johnson.
This is 24682 FC, people of the state of Michigan versus Jordan Johnson. Counsel, your appearance for the record.
Good morning, Your Honor. APA Burt Buxton on behalf of people of the state of Michigan.
Yeah, excuse me, Your Honor. Fred Blackman on behalf of Mr. Johnson. He's standing to my right at 40.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand on. Have you taken any medication yesterday or today?
No.
You're supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
You've had an opportunity to speak with your attorney?
Yes, Your Honor.
Have you had an opportunity to review the pre-sentence investigation report?
Yes, Your Honor.
And sir, you pled to count 2, assault with intent to do great bodily harm, less than murder or by strangulation, punishable by 10 years. Count 3, weapons carrying concealed, punishable by 5 years. And count 7, assault with dangerous weapon, also known as felonious assault, punishable by 4 years. You recall that?
Yes, Your Honor.
All right, do we have a victim here on behalf of the people?
Your Honor, double check.
All right, and then are there corrections, additions, deletions?
Jalen Nelson here. No, Your Honor, I do know that the detective is here, but the victim is not.
Okay.
I do have some changes, Your Honor, to the body of the report. In reviewing the criminal history that our office has, it looks as though probation had missed some of his juvenile history. I do have a copy of that information, if I may approach, Your Honor.
Right.
I have given a copy to the fence already.
Thank you. Thank you. So can we just add this in?
Yes.
No problem.
Okay.
And then we would just need to, on the report on page 4 of the pre-sentence investigation, change the case with juvenile history to number 3 of 3.
That change has been made. I've added this page right before that. So hopefully it makes sense when they do the corrections. Okay. Any other corrections? And with that, do we need to, are there guideline changes because of that?
Correct, Your Honor. I was gonna get to that one.
Okay.
I don't know if there are any more changes to the body by defense.
Any more changes to the body?
Yes, Judge, if I might, just one. My client was arrested on 7/19 of 2024. Probation agent says he was out in December of 2024. Judge, he's been in jail since the 19th day of December when we pled and the court reduced his bond to PR. When adding all of that up, Judge, I've got 544 days. If you take a year off of that, which was all of 25, got 179 days left. So he's basically he was in jail for a year and a half, 18, close to 18 months.
Okay, so let's change the date on that. So it's July 19th, 24 until when?
December 19th of 2025.
Okay, I've changed that and changing that under 22 and 544, striking the 158, and I suspect that's somewhere in the body too. Oh, I guess I don't see if they put that in there. Oh, yes, under a recommendation narrative, where it says he has credit for 158, I'm changing that to 544. All right, then are we good?
I may have to correct that now that I've talked to you. Judge, I've been thinking about, I'm sorry, they were drilling my head for melanoma. My brain went.
Okay, did you find it at page 2?
Yeah, Judge, let's do it this way. The dates that he was incarcerated would have been from the date first in 2024. It's actually December 19th and not today. So I'm back down to it, Judge, it would be 353 days in 2025 plus 160 days in 2024. If I add that now, then that would make it 513 days he's been in instead of the
544.
yeah, and I apologize about
It's
that.
okay, let me just change it now. So what are the, I have 7/19/24 to 12/19/24, or 25, I'm sorry?
Yes, ma'am.
And what's the second set?
I mean,
Are those,
those are dates because he's been out since then. So those are the dates he was
okay, so
incarcerated.
that's 513?
Yes.
Okay. It's okay, no attorney that I know is a mathematician, so we quite often change our minds on numbers.
I can remember that, golly, yeah.
Okay. So. I've corrected it again. Okay. Any other corrections, additions, deletions, and is there changes to the body of that, or to the guidelines of that?
Judge, no other correction or additions in the body report. The guidelines, I talked with the prosecutor and he's going to put on the record what they are, and I do not dispute that, Judge.
All right, thank you. By stipulation, what are they?
Just real briefly, Your Honor, I will say I just put it in a date calculator from 7/19/24 to 12/19/25. It is 5/18, not 5/13.
5 days, Judge. Okay.
All right, wow. You know what? I gotta change it again.
I know, I apologize, Your Honor.
5/18. Is that a final offer?
That is, yes, the people would stipulate the 5/18, Your Honor.
Okay.
Let me just make those changes before I talk about stipulated changes to the.
And I've also made those changes on the basic information sheet.
Correct. So in regards to guidelines, Your Honor.
Give me a moment.
Oh, I apologize.
Okay, now I've made all the changes, there are about 8 of them, so, all right, great. As to the guidelines,
Yes, Your Honor, in regards to count one, the assault with intent to do great bodily harm less than murder or by strangulation. Based off of the cases that I just added from the defendant's criminal history that did not make its way into the report, that would now mean that the defendant has 3 prior misdemeanor convictions or prior misdemeanor juvenile adjudications, which would then change PRV 5 to 10 points. That would then,
changes been made,
the total would change to 30, and that would change the PRV level to D.
okay?
That would then change the sentencing guideline range on that count, Your Honor, to 19 to 38.
Okay,
That PRV change would need to also be made to count 2 and count 3 as well.
identical,
Yes, Your Honor. It would, the guidelines would be a little different.
all right. So let's go to the CCW, so the PRV goes from 2 to 10. And total PRV is 30, level D, and what's the range?
So I do have some arguments in regards to the offense variables for count 2 as well, Your Honor.
Okay,
In regards to OV1, it is currently scored at 5 points. 1 second, Your Honor. So it's currently scored at 5 points. A weapon was displayed or implied. However, Your Honor, as you can see in all the other counts, OV1 was scored at 25 points because there was a firearm that was discharged at or toward a human being. So I believe that OV1 should be scored at 25 in regards to count 2.
okay, I'll go defendant.
I don't have a problem with that, Judge.
Yeah, if it'll be consistent, the court
Yeah.
has changed it to 25.
And then in regards to that same consistency, Your Honor, OV3 is scored at 0 for count 2. I would say that OV3 should be scored at 10 to match with the scoring in regards to count 1 and count 3, as there was someone that was injured due to the bullet.
Mr. Blackman,
No objection.
changes been made.
That would change the OV level to total to 35.
Guidelines,
1 moment, Your Honor. The guidelines would be 12 to 24. And I believe that changes the OV level as well. Give me 1 moment. That would change the OV level to 4.
changes been made.
And then in regards to count 3, it would just be the changes to the PRVs, changing it to total PRVs of 30 and a level of D, and that would also change the guidelines to 10 to 23.
All right, let me change the basic information sheet to reflect the scorings. All right, thank you. And you said there is no victim here. Is there anyone else who wishes to speak, or do you have a statement you wish to read?
No, Your Honor.
All right, on behalf of the people, what would you like me to know?
Yes, Your Honor. I understand that the recommendation in this case is to 365 days in jail. However, that was prior to the changing of the guidelines, as the guidelines now for count one are at minimum 19 months to 38 months. I believe that prison is appropriate in this matter, Your Honor. This is a very, very strange situation where the defendant was involved in what seems to be some kind of catfishing scandal. And when the victim ultimately did not comply, he pulled out his gun and started shooting at the driving away victim, Your Honor. That's a very, very dangerous situation. I'm very concerned with his behavior in this case. And due to the fact that he was not even the one, he was the one that set up the situation and then shot out his gun afterwards, Your Honor. The people are concerned with the safety for the community, and I believe that a prison guideline range would be appropriate in this matter, Your Honor, based off the situation in this case. Thank you.
I just want to make for the record, under the recommendation narrative paragraph on page 2, I've also changed the guidelines.
Thank you.
So the ranges are consistent. All right. On behalf of the defendant.
Number of things. First of all, in the courtroom is his mother and some other friends. The court let him out after that extended period of time in jail, and we were very, at the time we let him out, I was concerned about no further misconduct. That would be a problem. He has not. He's been doing everything that he can. He's already applied at Taco Bell. He's got an appointment to apply at Wendy's tomorrow, Judge, and he's also taking the necessary steps to get back in line with society and do the things necessary that he has. His mother could come up and say what he's changed after this extended period of time, which we're now thinking Judge is right around 17 months in jail. Understanding the guidelines, been changes in it, that the court is not necessarily bound by those guidelines at all. I'm asking that the court do the recommendation of 1 year in jail on probation with 1 year in jail, even extend the probationary time for my client. Understanding this particular situation, I'm not at all condoning anything he did, but if you look at his prior record, even the other two that were added to this court, guns or anything like that, have never been involved in anything. I went out to see him during a period of time that he was here. We always talked about coming before this court and ask for a bond. During that time, I said, no, you're gonna do some time. So you sit tight there and get things done while you're in jail. And he did. He never gave me a problem whatsoever. His mother was happy that he stayed in jail. This kid, from the first time I met him till now that he's been out since the 19th, it's changed. We've talked, he is a different kid. And again, I'm not discounting what got him to this particular time, but I think the court I think the court with a good conscience could put him on probation with the amount of time that he's already served, because that was a long period of time that he sat in jail without knowing what was going to happen on this particular thing. And I told him, the court does this, put you in probation and get you out there. You mess up, you're going to prison, and you can go to prison for a significant period of time for violating probation. So guns are a problem. This is a 2024 case. Obviously, nothing else happened because he's been sitting in jail, didn't get misconduct at the jail, did everything he was supposed to do in jail. And I'm asking the court to give him a chance. Give him a chance to prove to you that he can do the right things. And I would say that's significant amount. That is a significant reason that the guidelines may talk about not discounting the preparation of guidelines and the factors you put in guidelines, but I think, and I'd ask that this court take a look at him and take a look at what he's done since July of 2024 and place him on probation. Thank you, ma'am.
Sir, I'm sorry.
Your Honor, if I could just address what Attorney Blackman just said briefly. The detectives just reached out to me, informed me that the defendant did have multiple write-ups while he was in jail. So this wasn't an individual that was
What kind of write-ups?
Fighting.
Jail assaults. Assaulting other inmates.
And for the record, your name?
Detective Megan Jordan, Bingham County Sheriff's Office.
Could you spell your last name?
JORDAN.
Do you swear that the information you just provided is the truth, the whole truth, nothing but the truth, under penalty of perjury?
Yes.
All right. Anything else you want me to know?
No, ma'am.
All right, thank you. Sir, what would you like me to know?
I wrote it. Second, I would like to sincerely apologize to the victims, the courts, and my community for my actions. I take full responsibility for what I didn't understand, that my behavior caused harm and
Slow
disappointment.
down.
I apologize. I take full responsibility for what I didn't understand, that my behavior caused harm and disappointment. I regret my choices and the impact they had on others.
You gotta slow
I
down.
regret my
Disappointment.
choices. I regret my choices. What else?
No, it started after caused harm and disappointment.
I regret my choices and the impact they had on others, and I do not make excuses for them. Since this incident, I have taken time to reflect on my actions and the direction of my life. I have been actively working on myself to become a productive member of society. One of the steps I have taken is working towards getting my GED, which I see as an important part of building a more stable and responsible future. This experience has taught me a serious lesson about the direction of where my life was headed, my accountability, respect, and making better decisions. I am committed to continuing my personal growth and staying on a positive path and proving through my actions that I can change.
So, sir, what was going on in jail where you decided to get into some kind of altercations multiple times?
Yeah, it was stupid and definitely not worth it, but you know, you just around people for too long and you end up getting into a world of boys. So
This isn't a boys will be boys thing. This is a choice, bad choice after bad choice thing.
Yeah.
Because I don't believe in boys will be boys. I know you're young, sir, but do you want to be a bully who ends up in prison and is bullied by others?
No, it's not.
You're a big guy, but I can tell you there's a lot of other bigger guys in prison. I have sentenced them. And they are mean sons of bitches. And they would eat you for lunch.
I understand, Your Honor. No, I don't want to be like that.
Well, this record says that you want easy money to prey on women, prostitute them, give them gifts, to make all sorts of lies, and now we got you in jail and you're a bully. What you want me to do with that, sir? Did you like jail?
No, I did not, Your Honor.
I understand your mother's here?
Yes, Your Honor.
She a good cook?
Yes, Your Honor.
You got a nice bed in her house?
Yes, Your Honor.
Better than the jail?
Yes, Your Honor.
Well, let me tell you, it's kind of like Goldilocks and the Three Bears, you know, one bed's horrible and the next bed's kind of, you know, just a little bit better, and then the one bed's really good. You're going backwards. You're going from your mother's really nice bed to kind of a medium bed. The prison bed is horrible. The situation's horrible. It's gourmet food in the jail compared to what's over in prison. It depends on what kind of life you want. You were born to freedom, and you were born to greatness. But if you choose to go down a path that lands you in prison, you were also born to live in America to make that choice.
I understand, Your Honor. That's not the path I want to go down.
Well, how is it we have you in lockup and you're a bully? I can tell you that there is no police officer, detective, FBI agent, they don't want to sit here. They only show up when they are so very concerned and they want to send a message to me that, hey, something's got to change here because society is not safe with this person free. And the people want you to go to prison. So talk your way out of prison. What do you want me to know?
I just want you to know that I'm really sorry for what I did. Being in there, it gave me a long, hard thoughts, like thinking to myself of what I've been doing with my life and how I don't want to be in a jail cell. I don't want to be looked at like some crazy person, hurt people and hurting my family and friends. And I do want to better myself, and I have been trying to make that step to better myself.
What do you want to do with your life?
Right now, my goal is to get my own car in my apartment. I was just currently working at Speedway, but my boss had to let me go because of my background check, unfortunately. But I have been, I was working there for, as soon as I got out, probably the next couple of days.
Okay, but you told me what you want. Who do you want to be in the future? You want to be a doctor, a scientist? You want to work at Speedway? You want to own a Speedway? What do you want to do?
I want to work on cars. Like I want to have something to do with cars.
So you want to be some kind of mechanic?
Yes, yes, right.
Have you taken any steps for that?
I have applied to like car shops, but I haven't been successful in getting the job there yet.
Did you finish your GED?
No, Your Honor, I have one test left, but one of my next steps was to reach out to LCC. I was working third shift, so my schedule was kind of wonky. But now that I'm not actively at that job anymore, that was one of my plans.
All right, so you're going to be on probation for 24 months. You at least have to do half of that. If you continue on a good path, maybe you'll be released early. Otherwise, I can keep you on my watch and be the mother that you hate for 5 full years.
Yes, Your Honor.
I can also send you to prison. You're all out of jail time.
Yes, Your Honor.
So if you become a problem to our community, you'll be having that bus ride to prison. There's no more jail time.
I understand.
You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drugs paraphernalia. If you have the need for any of that, you'll present a prescription from a licensed medical physician within 24 hours. You'll comply with all requirements of drug testing if there is any, and alcohol testing if there is any positive. There'll be a secondary test at your expense, and then we will look at possible treatment or maybe prison. Doesn't look like you have a huge drug or alcohol problem, although you have used alcohol and marijuana. Are either one of those things a problem for you?
No, Your Honor.
You will complete your GED and you will go over to LCC, apply for the Reconnect program. It's free. You can get college and you can get your training there. If you don't have the proper training there, you will find some kind of technical school so you can fulfill your dream. Probation can help you with that.
Yes, Your Honor.
You will complete anger management. You will remain employed. If you're a full-time student or in a full-time training program, you only have to work a minimum of 18 hours. Otherwise, you, if you're not a full-time student or in a full-time program, you'll work a minimum of 30 hours per week. You will not give your employer any cause to terminate you. You will have 24 hours to give us any address, cell phone, or employment change. You will not have verbal, electronic, or physical contact with Jalen Nelson directly or through another person, and you will not be within 1,000 feet of her residence, school, or place of employment. There'll be no contact. She doesn't exist in your world. No direct contact, no contact through third parties, no smoke signals, Hallmark cards, flowers, carrier pigeon messages. You get creative, you go to prison.
Yes, Your Honor.
End up with the same Myers, you go to a different one. I don't care what's on sale. I don't care how long you spent putting the stuff in your cart. There's Myers all over town. You go to a different one. You end up with the same church service, you go to a different one.
I
You
understand.
end up with the same Taco Bell, you go to a different one.
I understand, Your Honor.
You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections or who is on parole or probation. If you need to have contact with any of those people, you will advise us and we'll give you permission, and you'll only have contact as long as everybody is in good standing.
Yes, Your Honor.
You will contact your probation agent today. Council will make sure that you go downstairs and make and keep your appointment. You'll comply with all written and verbal orders of all treatment providers and probation. You'll sign all necessary releases so we can verify that you're doing what you need to do.
Yes, Your Honor.
You'll allow probation into your residence at any time for probation supervision without a warrant and submit to a search of your person, vehicle, residence, cell phone, and computer without a warrant if there's reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest or police contact, personal protection order placed on you, loss of employment or change of residence within 24 hours. Weekends and holidays are accepted. So if something happens on Friday, tell us on Monday. Monday's a holiday, tell us on Tuesday.
Yes, Your Honor.
You'll serve 365 days jail with credit for 518 days. It doesn't appear that there's any restitution due, is that correct?
There has been none that's been requested at this time, Your Honor.
You'll pay a crime victims assessment in the amount of $130, and you'll pay a state cost in the amount of $204, that's $68 for each count. So that's a total of $334. You'll make regular payments on that. That will be paid by the end of probation. You will not use any object as a weapon. You'll not own, use, possess, purchase, or be in the presence of any weapon, imitation of a weapon. You'll not be in the presence of anyone who has those items. You will not have any affiliation or contact with any known gang member. You will not wear any gang tattoos, insignia, or colors. I'm not doing the monitoring. We've been monitoring. Essentially, there's no violation, so I'm not doing any of that other monitoring unless I see it's needed. So
He's had on a tether since his release is okay.
there's a tether on right now, so
Yes.
I'm going to remove the tether. I don't
Okay.
see the need for that at this moment. You have 42 days to appeal and to request appellate counsel.
He has a copy of that.
You acknowledge receiving your appellate rights?
Yes, Your Honor.
All right, just wait for that tether form and counsel will give you the copy of that and then he needs to go downstairs. Do
Thank
you have
you.
any questions, sir?
We have no questions. Do you have any questions? Me, yes.
Thank you, that's all for Roger.
Can we approach it?
Yes.
Well, shit.
Oh. Figured that, we were laughing about that.
I know.
Well, better her than you.
Yeah.
I don't think we'd want you on the roof.
Actually, I mean. I can tell you, you get her.
That's funny.
Thanks.
Yeah.
Fred, I think check these copies.
Yeah, okay.
AG on Zoom yet? No?
Do we have the Attorney General on? Do we need to reschedule or dismiss? What's going on with this? What is it?
Final pretrial.
It's a final pretrial for failure to pay child support.
Who's the defense counsel, Mr. Kaplan, is that?
Yeah, who was on Zoom, I'm not sure.
Yeah, Mr. Kaplan,
Yes, Your Honor.
have you had contact with the Attorney General?
I emailed her yesterday and she responded. I didn't remind her of the hearing date, but I assumed that she knew it. Jesse Green stood in for her at the last hearing on November 18th.
Well, what's this, without going into a whole lot, 'cause I don't want to talk about it with opposing counsel, what's the status of your client? Is he here?
He's in Maine, Your Honor. The court was aware of that last time. We let you know he was in Maine. He's on Zoom right now. You let him
Is he
appear because
paying?
he's,
Let me ask you this, is he paying support?
He had completed, he completed a wage assignment. We had some controversy about that last time. I got word from Miss Brenner that he paid $400 in December and $400 in January. And I think he's waiting for his next wage assignment this month. That should happen
All
soon.
right. Well, it is now 12:20 PM. It appears that there was notice to the Attorney General's of this case, and you've had conversations. It also appears he's making payments. I'm dismissing this, they can reissue. So I would suggest that your client keep paying. If people don't care enough to show up, I'm not keeping people hostage on my docket. So this is dismissed, they can reissue, but I would suggest, counsel, as long as he's paying, maybe they'd reconsider.
Understandable, Your Honor. And will that cancel the wage assignment then?
It better not.
Okay.
The wage assignment should be in place because he should work that out with the front of the court, because all that's gonna happen is they're gonna reissue and rearrest him, bring him to Michigan, he'll have extradition, and it gets worse and worse and worse.
Okay, because I don't understand the dynamics here. So if the wage assignment is attached to this case, and this case is dismissed.
He needs to do another one coming out of his check.
Okay.
On his own accord, because the front of the court will re-report him, and this cycle will continue, and if he's not gonna pay or give a crap, I've got the other file, and perhaps I just put him in jail so he doesn't pay that way.
Understand, Your Honor. I just wanted to.
I appreciate that. So, but when I have attorneys who fail to show up and it's their case, I'm dismissing it. We've not heard from her. They can reissue this. But I suggest, as I said, I don't work for them. I don't know what their policy is. There's a lot of child support owing, and I feel badly for the person that owes, but if he's got the wage assignment, he should do that without this case on his own, tell him how to do it, get it in place so they don't reissue.
Understandable, Your Honor. Thank you.
All right, so let me, I just wanted to have a conversation. So now that we're doing that, where is your client? I don't see him on here.
He's on Zoom right here.
Jeffrey Hurl. Correct.
All right, sir. I need you to be, okay, and unmute yourself. This is docket 254483 FH, People of the State of Michigan versus Jeffrey Hurl. There's no prosecutor here, and Jeffrey Kaplan is here representing defendant. Defendant is also present on Zoom because he lives in Maine. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
All right, so it looks like this was issued by the Attorney General. You had an outstanding arrearage as of November 16, 2012 of $18,053.90. I don't know why it took them so long to catch up with you, but they did. So my understanding from counsel is that you now have a wage assignment in place. Is that correct?
Yes, ma'am.
I had originally that there was a wage assignment in the amount of 6 cents. I trust that you have worked that out.
Yes, ma'am. I'm paying an extra $200 every 2 weeks.
Great. So, sir, the people didn't care enough to show. They're not in the hallway. Don't have any phone call that I'm aware of. Looks like notice was provided. I suggest that whatever you need to do, you do for that wage assignment to stay in place, because this is a huge arrearage and the Attorney General is just going to reissue this. It's going to land back in front of me. And if you decide to show me that you didn't pay and have not continued to act in good faith to pay your child support, I'm going to have you brought to Michigan.
I understand.
Okay?
Yes, ma'am.
Because of their failure, and I don't want this open on my desk, only to reschedule for people that don't care. I am dismissing this without prejudice, which means they could reissue it tomorrow. So take care of business, show them that you are paying, and let's just get past this, sir. You owe that money.
Yes,
There's a constitutionally protected right to those children to be provided for by both parents. You had the 5 minutes of fun. Now you've got the whole lifetime of paying for that. Get with it. Got it?
Yes, ma'am.
Thank you. That's all for the record.
Thank you, Your Honor.
Follow up on something else. So we'll have to take breaks.
We only have, after this one, 3 more. Yeah. Well, morning done.
Yeah, so
Given order of just.
this, are you, Kamari?
Yes, ma'am.
All right, this is docket 25-2774 FH, People of State of Michigan versus Kamari McCroy-Stump. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Barb Buxton on behalf of the people of the state of Michigan.
May it please the court, David B. Carter Jr. on behalf of the defendant who's present standing at the council table, standing at the podium.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand out of your head. Taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you had no time to speak with your attorney?
Yes, ma'am.
I understand this is a final pretrial. Is that your understanding as well?
Yes, ma'am.
All right. And on behalf of the people, what is the final offer?
The final offer, Your Honor, would be to plead as charged to count 1 and count 2. However, the people would agree to HYTA referral as well as a kilometer no upfront jail at the time of sentencing. It is my understanding that the defense does not wish to accept that plea offer at this time and move forward to trial.
How old are you, sir?
19.
Okay. People don't need to offer hideout, just granted, just for the record.
And I understand, Your Honor. I just wanted, for the purposes of the record, I just wanted to make sure that that was why we are doing as charged, because that HIDA was considered.
Okay. Counsel?
Thank you, Your Honor. I have it.
Accurate and complete?
It is, Your Honor. I had discussed that with my client. He maintains his innocence on this. I would like to also indicate that the prosecutor had sent me over 2 phone calls from the jail that was recorded, and I did play those over to my client that may impact his decision, and he still maintains his innocence and would like to go to trial.
Sir, the offer is at full, fair, accurate, and complete?
Can you say that again?
Is the offer that was stated full, fair, accurate, and complete? You would plead as to the charges, but you would receive a non-public record by completing probation?
Yes, ma'am.
Do you understand that if you go to trial, I can no longer give you HIDA? If the jury finds you guilty, you'll be found, if it's count 1, it's a 5-year felony, count 2 would be a 2.5-year felony. Do you understand that? And I can't give you a non-public record.
Yes, ma'am.
Do you want some more time to talk with Mr. Carter? You look a little puzzled.
Yes, ma'am.
So HIDA means that you plead and then you're on probation, and when probation's done, this is a non-public record. So if you apply to Myers, for example, they cannot see that you have a felony record. Only court personnel and law enforcement can see that you have a felony record, nobody else. So even if your mom calls and says, is there a file? Even if she knows there's a file, we don't acknowledge it to anybody. But if you are found guilty by a jury, I'm not allowed to give you that privilege anymore. HIDA is not a right, it's a privilege. It's something that was created for young people who make mistakes, so it doesn't hang around your neck for the rest of your life. Or until you can get it set aside in 5 or 10 years, whatever you decide to do it. So it's an important statute, and it's something you should consider with your attorney. So I don't know what happened. I wasn't there. I don't know anything. They don't even give me police reports. So why don't you spend a couple minutes, Mr. Carter, and he can answer your questions, because I think that a lot of people think that if they go to trial, they still can ask for hide it, and by law, I cannot. So let's go talk to Mr. Carter and then we'll see where we're at, okay? Thank you. Next matter. Hold on.
Tyran Stuckey. Yes, no more.
This is docket 25-3159 FH, people of the state of Michigan versus Tyrance Lamar Stuckey, and docket 25-3479 FH, people of the state of Michigan versus Tyrance Lamar Stuckey. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson standing in for Aaron Schroeder on behalf of Mr. Stuckey this afternoon, Your Honor.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
This is a final pretrial because we have to have you make a final decision, because I don't let people plead on the day of trial, because if you do that, then somebody else who wants a trial doesn't get it, okay?
Okay.
So have you had enough time to speak with your attorney in regard to any offer that was made?
Okay. Might I speak free for 1 second, please? My last court date I was here, you asked Aaron and the prosecutor to come to a conclusion that day, because I've been going through this for over a year now. You told them to come to something that day and me to stay by my phone. I stayed by my phone. I was never contacted by anyone. I've been reaching out to Aaron's office to find out what's going on. And she kept telling me she hadn't heard anything yet.
Okay.
Then through my kids, I found out I had this court date today. Hadn't my kids said anything, I wouldn't even be standing in front of you right now. This is what I'm saying is, they're not communicating right and they're not doing what you asked of them. And I just want this case to be over because I have done nothing. And I've stated this from the beginning.
So how did your kids know about the date, but you didn't? Did they get something in the mail?
No, they stay with their mom. They visit between me and their mom, and they was talking about, Dad, I know you're going to court. I'm not going to court.
Okay. Well, let me.
So I took it upon myself to come down here.
Okay, I appreciate that. So is there an offer? What's the status?
Yes, Your Honor, there is an offer in this case. Excuse me. The offer in this case, that obviously there is a global resolution in both files. In 25-3479-FH, the defendant would plead to count 1, felonious assault, and count 2, domestic violence. Upon successful plea and sentencing, count 3, the felony firearm, would be dismissed in that file, as well as the entirety of 25-3151-FH, which is a witness intimidation charge, as well as a habitual second offender status. There is also, as this is a straddle cell, there would be a kill-a-brew agreement to county cap at the time of sentencing.
Do you understand that, officer? It is that you will be pleading guilty to count 1, assault with a dangerous weapon, also known as felonious assault, punishable by 4 years. Count 2, a 93-day misdemeanor, and there'd be a county cap recommendation to me, so I could do anything between 0 and 365 days. And upon plea, count 3, the weapons felony firearm, which is 2 years consecutively with and preceding any term of imprisonment, would be dismissed, along with the witness bribing intimidation, which is a 4-year felony, and the habitual offender second offense notice. And because of that, that 4-year turns into a 6-year. So that would be dismissed. Do you understand what the offer is?
Your Honor, I understand what the offer is, but what I'm saying is, I've cooperated entirely from day one. This case is totally bogus, and I've been coming to all my court dates. I did 6 months in jail. I've been out, I did what I've been told to do, and he still has no witness. This case was just brung up on me. And during that time, this year's time, while I was locked up, she had possession of my home. My home has been destroyed. My vehicle's been destroyed. I have my possession of it now. No contact with her, but this case was all bogus from the beginning. I just wanted to be over with so I can continue with my life. I have medical conditions and things and trying to rearrange to keep coming down here to court. I just feel it's ridiculous. They're reaching out for nothing.
Okay, well, do we have a victim who has done a preliminary exam or who's willing to show up?
Let me double check, Your Honor. I know, so, Your Honor, with the witness intimidation, the people would be making an argument for forfeiture by wrongdoing and bringing the statements via that course of action. But let me check if the victim was present at the time of exam. One moment.
I mean, this was about a year ago. Has the victim been checking in, anything? Has your office checked in with the victim?
My understanding is that, my understanding is that it was ultimately waived at the time of exam.
So do we know if she wants to proceed or not?
My understanding, our office has had, I've attempted to make contact. Our office has had contact with her as recently as September of last year.
And does she want to move forward?
My understanding, yes.
Okay. Sir, I can't just dismiss it because you're unhappy about the time frame. We're within time frames. Apparently she's involved. I don't know. And now we have a second file, so.
Ma'am, I'm sorry for speaking out of turn, but can I please just say something? Please just let me speak to you.
Okay, but understand whatever.
I
you say,
understand
right,
I understand what you're saying to me, ma'am. But what I'm saying is this, that every time I come in front of you, you ask the same question. Has the victim been contacted? Have you reached the victim? And they keep telling you no. They had all this time to reach the victim. I did 6 months in jail and been out for 4. Why haven't they reached the victim?
And Your Honor, we do have a trial date of February 27th at this point in time.
All right, so sir, as to the plea offer, so if she doesn't show up for the trial, it'll be dismissed.
Okay, well, I'll just go to trial because like I said, I'm continue to say I'm not guilty because I did nothing wrong.
Sir, I understand. So do you understand the plea offer and you're
Yes,
rejecting
ma'am.
that? Is that okay?
Yes, ma'am, I
Did
understand.
anyone force, threaten, or coerce you to make this decision?
No, ma'am.
Anyone promise you anything that caused you to make this decision?
No, ma'am.
And you've had ample time to talk about all of this with your attorney and discuss options, and it's your decision solely to make the decision to go to trial instead of accept the plea agreement. Is that correct?
Correct.
And I know you've had a couple of attorneys, but you've been satisfied so far with counsel?
Yes, this the only, I mean, Aaron is the only attorney I ever had, the only counsel I ever had.
Okay, but you've been preparing for trial and everything with her?
I mean, this is as far as we didn't got as far as trial because I thought this was gonna be dismissed and gone because every time I've been in court so many times and you keep telling them to come to some kind of conclusion. And
Well,
I don't understand where's my
they've got an
justice.
offer. If there's no victim who shows up and there's not been any interference with her, then I'll be dismissed, but I can't just dismiss it on no ground.
I understand.
Okay, so I'll see you on the 27th for trial.
Thank you. Have a nice day.
That's okay. On-demand conditions are continued. Yes.
I don't know, maybe not quite that long now.
No idea.
That one's or move to next Wednesday.
Called it.
On that last one, I want the, well, even if the trial doesn't go, because it might not be first up, because it's 25, I want the victim here. She's either interested or she's not. I mean, this case has been a problem.
Well, and like I said, Your Honor, I'll be bringing the forfeiture by wrongdoing.
I don't care about that. I just, we gotta have a victim here.
Understood, Your Honor.
Or at least some communication she wants to proceed. We have not had any of that. So. Are we done?
Do we have to do anything on?
No, I'll see you next Wednesday.
The only thing still left on the docket, Your Honor, is Anthony Reed, but I see that Aaron Robinson's on the file. I'm not seeing Ms. Robinson today. I know Mr. Reed is here because he's in lockup, but I've not heard or seen from Ms. Robinson yet today.
What is it? Is it a
It's
final?
a sentencing.
Well, let's take a little bit of a break and call and see if she's on her way. All right?
Yeah, I don't.
We
I
have
don't
to
see
go back
any
on
here.
her.
Or Toby.
Carol? For that,
Okay. You want me to get,
Harold, oh, it's Ms. Harold.
you want me to get Teresa?
no, she.
Are you talking about Kamari? Because the Kamari one with David Carter, we just turned off the record.
I have most everybody in here
Not
except
that one,
Teresa.
Roy.
Yes, that one was turned off the record.
Okay, so we're not going back.
We're not going back on the record for that one.
Okay, thank you. Sorry.
I'm texting you right now, Your Honor.
There's no way to print. What the heck? Might not be able to go, otherwise you stay at home after I'm done. So we can go to Jake's.
She's on the phone.
Yeah.
Kathleen's gonna take a literally 0.5 seconds. And yours gonna have to be suppressed though.
Yes. She says it's at 3:30.
It's not, it's at 11:30. I see right here.
Where's what celebrity going to? You have a doctor's appointment for 15 minutes. You'll have to do that soon. All right. Weapons court today?
Yeah. Yeah, we have 5.
Let's say he's got a hold of Ms. Robinson. I think she may have had at times confused, so I'm trying to figure out her.
So. I'm gonna Judge Stokes.
Yep, we're just waiting on Teresa to get set up here.
Okay.
And one of them is
Yeah,
suppressed.
Want to do the quick bench warrant one that's not suppressed first?
Okay, yeah.
Oh,
that's fine.
hold on.
Which bench?
Well-
Which one is that?
Earl.
Nancy, you don't have to worry about it.
Huh?
I said Teresa's here, you don't have to worry about it.
Oh, so this, you're talking about,
Yes, still.
I thought you meant,
No, I'm sorry.
no, I'm sorry. Okay.
Okay, what do I have? Are you ready?
I'm ready.
Okay, thank you. This is docket 25-5566 FH, People of the State of Michigan versus Eva Jean Fuentes Earls. Counsel, your appearances for the record.
Good afternoon, Your Honor. Alina Cisneros on behalf of the people.
Your Honor, Jeffrey Kaplan, P 74943, on behalf of the defendant who is not here.
All right, I'm handling this case for Judge Stokes with family emergency. And it looks like this was scheduled today. What time was, I don't have her full docket. What time was it scheduled for?
11:30.
It is now scheduled for 11:30. It's now 12:45. The court has waited an hour and 15 minutes. She doesn't appear to be in the courtroom or the hallway. And I'm not aware of any phone call or information that she's in lockup. Therefore, bench warrant bond forfeiture shall issue.
Thank you, Your Honor.
And was this set for a pretrial?
As well as a show cause.
Correct.
Thank you.
Thank you.
And doesn't mean you shouldn't be drinking a soda, you just.